Hello and welcome to Simply inTAXicating. In our last episode of post-budget analysis, we are going to debate over a good number of amendments proposed in the finance bill with respect to non-resident taxation. Interestingly, all the amendments proposed virtually provide much sought-after relief to the non-residents, such as doing away with PAN requirement, Section 9A amendment giving relief to fund managers, deferment of POEM and many more. To discuss the real impact of these amendments, we have four guests in the studio: Mr. D.P. Gupta, the former Chief Commissioner of Income Tax, Mr. Sandeep, partner PwC, Mr. Pinto, partner Grant Thornton, and Palbi Dinodia from Issa Dinodia and Company. Let me go to Palbi. So Palbi, the fact that the PAN requirement is gone in this budget, but I guess you still have some more live issues. Would you like to share with us?
So my issue was that there was a dichotomy between 206AA and the treaty, because 206AA again was a unilateral domestic law provision that required a non-resident to, do compliance under a domestic law, which was not required by treaty, to get treaty benefit. So a lot of the foreign non-residents were subjected to this law and therefore not getting the benefit of the lower rate of tax as per treaty, because TDS are very onerous provisions under our act and disallowances of those expenditures happen. So therefore the clarity was required, and now there was a Pune bench decision also, IT80, which said that it cannot be in contradiction to the treaty and therefore PAN is not required. So I think this upholds that decision, but at the same time the rules of how that person then gets the credit of the deduction even as per treaty, because now credit is given electronically. Those Form 16s and 16As are now all downloaded electronically. So if you don't have a PAN, you have to have some other identification number, which the government then has to allow you to put electronically so that you get credit. So credit, I think, is an issue. And then once these companies who historically have taken a PAN, because this regime came in 2012. So in the last 3 years, all these non-residents who've got PANs are now being sent these notices for compliance and being asked to file ITRs. And when you file their ITR with no income taxable in India or no P&L balance sheet, it sends you a 139 notice for a defective return. And it gives you no ability to write online why it's a defective return. And the assessing officer has no idea of how to rectify the situation. So a non-resident who has filed a return because of a PAN to get benefit of a lower rate has not got that benefit and is stuck in a compliance conundrum in India.
Absolutely.
So I think a lot of clarity needs
to
be.
That's a very practical and useful point. I presume the CBDT must be aware of it. I do not know whether things are, but I have seen that, when you go for complete computerization without any human intervention, then unless you can specify, in absolute detail all the various combinations, it becomes problematic.
Correct.
So I think some kind of a solution is necessary, but I suppose what
they can do is, in fact, I don't know, a lot of people are not aware that the US also enforces the requirement to have a US TIN number if you want to take a tax credit in the US. But the good thing there is when you apply for the taxpayer identification number, the TIN number that they call, you can specify that you are obtaining this TIN number only for withholding tax benefits. So that information is passed on to the taxing authority at the time of, applying for that. So I don't know whether there is some, inbuilt algorithm in that TIN number that indicates that. But that's the information that is captured on day one on applying for the TIN number. And I think thereafter it makes it easier for them to file. What in the US you file a protective tax return along with a treaty-based disclosure statement which says that I'm relying on treaty benefit so and so article and this is why it should not be taxed. I think that's something that maybe we can sort of look at to try and adopt.
Yeah, Mr. Sandeep, you'd like to add to?
Whilst in 206AA, they have taken away this requirement of having a PAN and they will prescribe some format. It may be, because anyway, if you want to take a treaty benefit, you have to give Form 10F. So that anyway is required. So they will come up with something else, time will tell what they prescribe. The point is that assume that a non-resident has a royalty income, okay, and under the treaty it is getting taxed at 10%, and does not have a PAN, so the payer was deducting 20%. So the question is two questions. One, whether in the home country he will get a credit for 20, the answer could be no, because that country will say, I'll give you credit only to the extent of rate provided in the treaty. What happens to the differential 10, the additional 10? So for that, he can claim a refund by filing a return of income, and I agree with you though the practical difficulties. Now what will happen, that this non-resident has not taken a PAN, okay, and the TDS deducted on his income is 10% as per the treaty, provided he is given all the other details.
Right.
When he goes to, now the question is the non-resident required under the Indian law to file a return of income or not? So he has an obligation to file a return of income, even if it is a royalty income subject to tax at gross basis. When he seeks to file a return of income, will the requirement of having a PAN in such case be dispensed with? Because otherwise, how will he file a return of income?
True. Absolutely.
Either you say that if you are getting taxed on a gross basis, the requirement of filing return is not required, that you have not amended.
Correct.
So that's, section 115A or 115G, the dispensation is only for NRIs in certain cases, not to NRs for others.
Correct.
So would that mean that again he will have to apply for a PAN?
Absolutely.
Or a new number.
Or a new number. Or they will come up with some new number.
Yes, certainly. So I'm sure CBDT must be working on this, sir. I think that they are quite sensitized about this issue. This is being debated.
They have come with an identification number for FATCA filing, so maybe they can.
So maybe they'll come up with something else.
Yeah, absolutely. So that brings us to this offshore fund, Section 9A amendment. Mr. Pinto, you would like to talk about this?
So I think from a fund manager perspective, I've got a lot of happy phone calls from the fund managers based here. So I think that was a clarification that was probably long awaited and probably lobbied also by this industry. Of course, we as a country are definitely still looking for investments from FIIs as well as overseas funds. So this litigation along with MAT and this requirement of a business connection because of fund managers was creating a lot of friction to this industry. So I think in my view, it's a welcome sort of relief. We are anyways taxing them or providing them treaty benefits to not tax them on the various regimes. So just using this as a matter of litigation was an unnecessary hurdle in their business profile. So in my view, it's a welcome relief.
I completely agree.
Yes, Sandeep.
This is a good step brought by the finance minister last year to introduce, and again goes back to the earlier thought that we should have the fund managers, and most of the fund managers in Singapore and Hong Kong are all of Indian origin.
Correct.
So why they are sitting there? Why can't they be in India?
Right.
So good thought and a good provision which was brought in last year. But with about 17 or 18, I don't remember, I think last year when I counted about 17 conditions. Conditions on the corpus of the fund, how many members it should be there, how much they can invest in one entity, how much of income he can earn, etc. etc.
Yes.
And 1 and 2 conditions which were in addition, one of those 17 and 2 conditions very onerous was that this dispensation that will not create a business connection would be applicable only if the fund is from a country with which India has a treaty or with which it has a tax information,
tax information.
So, and we know that there are these funds may be located in jurisdictions where India does not have a treaty, and let's be practical about it. So I think that's a good move here. The other one was that this fund manager cannot be managing business in India or managing business from India. Now, managing business in India, one can understand that you have invested into Indian company or you go on a board of directors of Indian company. So managing from India. So that managing in India. So that still remains. So if he's managing in India, then he doesn't get the benefit. Managing from India, they have dispensed with. So I think it's a good step. But again, whether it will attract people who are there in Singapore, the fund managers in Singapore, Hong Kong or elsewhere, to move to India, I think it's still a long way to go. Because of this still 17, 18 conditions, India will have to slowly move towards that. And I think there are the good steps being taken year on year. Like for example, in a different context, International Financial Center that they are bringing.
All these things are right, but I have got one issue with the all these exceptions that we are making.
Sir.
I think government should also at periodical intervals examine how far they have been successful.
All right, so correct. Okay.
There is no point in just giving these, whether they've been received, whether they've been successful, how many jobs you have created, how many fund managers have come. Otherwise, every year you will find one more demand.
True, sir.
We have not been able to do this because of this. So there is the government gives some incentives, fine, but government should also evaluate
clear-cut nexus with the objectives.
How is it working?
Yes.
Whether
No,
it is working.
I agree with you, sir. I agree with because there has to be a reality check that this how many fund managers from Singapore or Hong Kong, what you intended, how many of them have moved to India?
So that brings us, I think most of the issues that we have discussed. The only thing which I find now left is the special notified zone for this foreign mining company, where they have done little bit of clarification. This clarification was, I think, called for quite some time. I mean, since you happen to be in Mumbai and this zone happens to be there, all the diamond, the actual diamond and the human resource diamonds like Mr. Pinto are there. So maybe you would like to comment on this.
No, I've not seen that.
Okay.
Declaring, maybe Sandeep has a better view on that.
Yeah, Sandeep, you are aware of this particular amendment which they have done with respect to FMC, foreign mining
only
company?
for display. What they are saying is that if you bring in diamonds for display, then it will not constitute a
Business connection, so that's all. So that means there must be certain cases pending somewhere, some notices being issued.
Which is in line with the most of the treaties, Article 5.3 typically, that if you're only displaying that.
Yes.
So I think it's more.
Yeah, of course, we have got our position on the display.
Display.
And the BEPS also has now going to do away with the display part. So there is an issue. But at least, in the business connection part will not be there. So
right.
Whether it will come under treaty or not, I do not know. It's not a very big thing, I suppose.
Yes, it's clarificatory in nature, sir, too. So, is there anything else, Palbi? I mean, maybe, this final round, any other point which
there is one point, this place of effective management.
Poem, yes, we were missing the most important point, yes.
Place of effective
We have also deferred our views
yes, so
along with the government.
no, let's not defer poem, sir.
One is
of course, song.
One is that it's been deferred.
Right, correct.
I mean, why it came in, it's a long story.
Right,
it was rightly changed.
Right, sir.
Along with the deferment, what they have done is that they have introduced a section 115JH.
Right, sir.
Which is a special provision relating to foreign companies said to be resident in India. I suppose because this comes out from the explanatory memorandum, is that because of the application of POEM,
right, sir,
some non-resident companies might become resident for the first time.
I see, sir. Okay.
Which were not resident earlier.
Right. Sir.
So how to compute their income? Whether the question of whether the depreciation, etc., can be allowed to them, can be carried forward with the setup and absorption of
various kinds of deductions. Yes, sir.
All those things. So they have introduced a section for that, and of course it is again subject to the conditions as may be notified by the government, so they have not formed up their mind.
Right, sir.
So, but the issue is that if because of the application of POEM, some companies become resident in India for the first time, then the clarification is that the certain provisions will apply to them. That's
absolutely. Right,
but
sir.
there is no reference to in 115JH. There is no reference particularly specifically to the poem.
Right, sir. Mr. Sandeep, why in the first place, what was the controversy? What clarity was really demanded by the industry and trade and
on the poem?
On the poem, which led to this, which triggered this debate inside the government, and finally government decided to defer it by a year or so.
See, it was, when the poem was introduced last year and the definition, what place of effective management is. So, clarity was sought by the industry or the taxpayers that, when you say where key management and commercial decisions are taken in substance for the entity as a whole. So, what does it really mean? Because you can have companies Indian company which has subsidiaries overseas, they have their own boards taking decisions, whether it will apply here. As a shareholder, I can always give my suggestion. If I'm a substantial shareholder, I will say, okay, this is what you want to do. My sense is, our analysis, it should be done in this manner, because I have to protect my interest as a steward, as a shareholder. Whether that will imply that the decisions are being taken in India. So a lot of questions were there. Active business, passive business. So pursuant to that, they came out with guidelines somewhere in December, and then comments were sought till the first week or second week of January. Comments were given across industry, and then nothing happened in that sense. And then we had the budget. So therefore, I think the thought within the ministry was that the entire year has gone by, and the guidelines have not really become final, because these were again subject to a lot of scrutiny and comments by the industry, on what is active, what is passive, and then what circumstances are passive. You are saying that it becomes the company becomes POEM in India, and the transitory provisions that Mr. Sen Gupta is talking about. You decide a POEM at the end of the year, and it's what will happen to withholding tax, what will happen to all the other compliances. So the transitory provisions they have taken care of this year. So but the point is that when they say we have deferred POEM by 1 year, or they have deferred POEM, it actually is a deferral only by 1 month, because the POEM was in effect from financial year 15-16. Only because we are waiting for the guidelines, and guidelines did not happen. So on 29th of February, when you say that we are deferring POEM, so it is now effective from 1st April 2016. And therefore, it makes much sense for the government to clearly now bring out the final guidelines, to clarify, so that if the POEM is effective from 1st April 2016, we have the guidance available as to in what circumstance it will apply, what circumstance it will not apply.
It's true, absolutely. Yeah, Pallavi, you would like to add something?
So the guidelines, in my view, were not clear at all. Because they left so much open-ended. It's it said many things were explained by way of examples, and then it said, but still, this is really not the final. The government can still look at something else. So I think POEM is such a thing in which, you're trying to say that a non-resident will be taxed in India, subject to these conditions. And maybe it's not a bad idea to have those 17 type of conditions which are absolutely clear. Either you meet it or you don't meet it. These ambiguous conditions are what then creates the controversy and the litigations going forward. So I think a lot of clarity is required in those guidelines.
Yeah, Mr. Pinto.
So I'll pick on that word ambiguity. I think when I talk to a lot of clients, international clients, that's the key thing that they're worried about India, is they don't mind paying taxes as long as they're clear before they enter into a transaction. What is it that is going to be taxed and how it is going to be taxed? The ambiguity that usually prevails, in new legislations that we introduce is something that bothers them. I think the same thing is about POEM, and that it's a significant legislation. It's Indian MNCs. We have a whole host of Indian companies going global, and a lot of them may traditionally have been effectively run from India, because substantially there are a lot of decision makers who are sitting here. So I think clarity is very critical as to what is the meaning of management and these decisions. What is key? What is considered key? Each and every word of that, each and every stanza, I should say, of that POEM needs to be pretty clear before we start implementing them.
General fear is that it should not be a poetic justice.
Or injustice.
I am used to taking a contrary view on many of these issues. First, we should understand why we have changed it. People were just floating companies abroad, managing everything from India, and said, okay, my residence is... Your control and management had to be wholly in India. Even if you had one board meeting outside, the present position, you are a non-resident.
You are non-resident.
Foreign income is not subject to tax in India.
Right, sir.
So that is the basic issue. That's the reason why they changed. Okay, they changed to a concept called place of effective management. Now this is... Interestingly, this place of effective management used to be the tiebreaker rule. for in the OECD Model Convention as also in the UN Model Convention. Now, it was a tiebreaker.
Right, sir.
Now, the problem with this concept is that nobody knows what exactly is the meaning of place of effective management. Even the OECD countries do not know. And because in some countries which say that it is the director's control, some countries which will say it is the other executives who take the senior management that control. Some countries will say it is the shop floor management that is important.
Right,
so what the OECD has done is that it has actually in the BEPS project, this is one of them, because this is how you can move. This is also how you shift profits.
Right, correct.
So it is part of the base erosion and profit shifting project. So what the OECD now says is that we are giving up the place of effective management concept altogether. It will be decided on case by case. So that's in a treaty concept, treaty context. But in the domestic law, you must have residency concept.
Right, correct.
Now, you can either depend on your incorporation, which the USA does, only incorporation and nothing else.
Nothing else, yes, sir.
Now, there are problems there. If you have only incorporation, the USA itself is facing the inversions.
No problem, yeah, absolutely.
But they at least have CFC rules to sort of
and they have at least CFC rules too. We
Yes.
don't have anything.
We don't have.
So we need to have something. Now, how much of the clarity you can bring in is something I am doubtful.
So on this note, let me first thank all my 4 guests for churning out all the possible implications of the amendments proposed. I agree with Ms. Palvi, who did welcome the doing away with the PAN requirement for non-resident, but the problem of tax credit remains unresolved. I am pretty sure the CBDT would be looking into it to find long-term solution to this issue. Another pertinent point raised by Ms. Palvi is that if a non-resident earns some royalty income and has no P in India, whether the non-resident would require to go for a fresh PAN or the CBDT would be prescribing some other documents which can take care of this problem. Section 9A amendment is certainly a welcome change, but all the cases agree to the suggestion that the impact of such incentives should be periodically evaluated to see how many fund managers have really moved back to India from Singapore or other places. As regards the poem, although it was announced that it would be coming into force from assessment year 17-18, but it basically means an effective deferment of 1 month as it was initially planned to be effective from April 1st, 2016. Thanking you for watching TIOL.